What happens at a preliminary hearing in a criminal case? We'll answer that question in this video. My name is Veronica. I am a criminal defense attorney here in Los Angeles, and I help people who have been arrested put their criminal cases behind them so that they can enjoy their lives and their freedom. And again, in this video, I'm going to be explaining what happens at a preliminary hearing. I do have several more detailed videos that kind of go into more of the same about this stuff. So if you are interested, go ahead and search my channel. You can find those. But this is part of a series that I created. It's part 3. With a criminal case timeline. So basically, and you can actually download this down below. Basically, I found that a lot of people who have criminal cases see that there are these court dates set and they're like, what the hell is going to happen at this court date? I have no idea. And having, I think, an overview of what to expect can help quite a bit. So this is something I actually give to my clients. I'm just giving out here for free. You don't even have to give me your email address, nothing. It's just down below. Anyway, so first of all, let's talk about when you should expect there to be a preliminary hearing. Now, this is felony criminal cases in the state of California. But within those cases, when should you expect, when is there going to be a preliminary hearing? So you're going to see on this criminal case timeline that there are going to be a bunch of check-in dates after the first court date where we're negotiating with the DA and trying to get the best possible deal, whether it's a dismissal or whether it is some kind of plea deal on the table. And ultimately, in most cases, after several rounds of negotiations, maybe some motions filed, we are able to get a deal or dismissal, something that our client is happy with. But if the DA does not provide a good enough offer in the case during those check-in dates, or sometimes in these cases, the DA will say, well, I want to see how good my witnesses are, and I'll explain that in a minute. Then there's going to be a preliminary hearing. So a preliminary hearing is technically a probable cause hearing. It is to see if there is enough probable cause to proceed. So this example, this may or may not resonate with you, but I was watching with my fiance last night, Jack Reacher. It's actually pretty good. It's like an action show on Netflix. Anyway, at one point, there's a police officer who is threatening Reacher, saying that he's going to, throw him in jail and charge him with murder. My fiance's like, well, can he really do that? He doesn't have any evidence. And I explained, okay, well, at the preliminary hearing, I think that show takes place in Mississippi. I don't know what the procedure is there, but at this preliminary hearing, at the probable cause hearing, the prosecution would have to show that they have probable cause to move forward with the case. And if they didn't have enough to show that it is that there's a reasonable suspicion that the defendant committed the crime and that there was in fact a crime committed, then they wouldn't be able to keep him there. They'd have to release him. But if the judge, for example, said, well, I'm not really sure, I think there is enough, then he has to go to trial. My fiance is like, well, wow, that sucks. Anyway, this preliminary hearing is a probable cause hearing. It is supposed to be a protection against prosecutions where there is basically no evidence. Now, the standard to hold someone to answer, to find that there's enough evidence, is probable cause. It's the same as to arrest someone. So people get arrested all the time with very little evidence, right? So most of the time, these cases aren't going to be dismissed at the preliminary hearing. In that case of Jack Reacher, there was actually video of him on a Greyhound bus someplace else that presumably would have been presented at the preliminary hearing to show that it couldn't possibly have been him. But what you should expect at the preliminary hearing, I think you know by now, probably the defense is not going to win that preliminary hearing. I mean, you would have to have evidence that is extremely clear in your favor as the defense. I don't mean a witness. I mean something hard evidence, usually, for the judge to dismiss it. Or the prosecution would have to really screw up or not have their witnesses. But what it is an opportunity to cross-examine witnesses and to show the DA, if you think their witnesses are going to be problematic, to show them that. So in LA County, the preliminary hearings are primarily done by baby DAs, by brand new DAs, to give them practice. They don't talk to their witnesses. Like, you would think that, hey, if you have witnesses for your case, you're prosecuting someone, You've talked to them. You know their story. For most cases, that's not true. For some it is. For some bigger cases, that is true. For some specially assigned cases, that is true. But for the most part, that is not true. The DAs actually don't even meet their witnesses, let alone speak to them, let alone meet them, until the actual preliminary hearing day. So when I'm talking to my client who does many times know the witnesses, or I'm talking to my client's witnesses who may know the other witnesses, we may have a good idea that there are going to be significant problems with the prosecutor's witnesses. But the prosecutor doesn't know, and of course isn't going to just believe a defense attorney, right? So sometimes they have to show up and I have to catch them in lies or pin them down to a statement that's really inconsistent to what they said to the police to begin with, and then talk to the DA and say, hey, you guys wouldn't give me a good offer before, but now I've shown you your witnesses suck. You can't win this at trial. And sometimes that is what we need to actually get the case resolved or something that is positive for the client. Discovery. So sometimes, and I mentioned this in part 2 of this little series, I mentioned that, you would think that to prosecute someone for a crime, they would have all the evidence, basically in a box, right? Depending on how much there is. They would have a big stack of it. And they would just hand the entire box to the defense attorney, to the defense, and here you go. Now we all know what the case is about. We can look through it and we can resolve the case, right? But that is not how it works. It is like pulling teeth sometimes, and it takes a long time as evidence sort of trickles in through the police, to the prosecution, to the defense. So sometimes, if it's been taking a long time, it's been pulling teeth, and I have the detective on the stand, then I can just ask him, okay, was there any body-worn video? Did you record that interview that you took? Right? And I want to get him nailed down, and that's sometimes my only opportunity to actually get the cops nailed down before trial to whether a piece of evidence for sure exists or does not. Now, at the end of the preliminary hearing, the defense is going to make a motion to dismiss based on insufficiency of the evidence. We're going to say basically that there is no probable cause. There is no reason to believe that a crime was committed and that the defendant committed it, and or that the defendant committed it. That motion is almost always going to be denied. Sometimes there's some technicality, sometimes some element is really missing and the DA really messed up, but for the most part, the case is going to get past the preliminary hearing. Sometimes, and early in my career, I not forgot, but almost didn't even think to explain to clients that when the judge says, I find sufficient cause to show that the crime of whatever it is, murder was committed and the defendant has committed it, I'm going to hold him to answer, we'll come back on this date. Some of the clients, and don't worry, it wasn't murder super early in my career, but were panicked and they're like, oh my God, does this mean I'm guilty? No, it doesn't mean you're guilty. So now I always make sure that I explain first, okay, this is what's going to happen. And when the judge says that, that's fine. That's normal. It doesn't mean anything. It just means that they're not throwing the case out, which we knew was going to be the case from the beginning. At that time, the defense attorney may also make a 17B motion, depending on the charges. 17B is a penal code section that allows the judge to reduce certain felonies, wobblers, which if you're researching this stuff, you probably already know what that is. But it's a felony it's a crime that could be charged as either a felony or a misdemeanor. So if it's a felony, your defense attorney can make a motion at that time to reduce all felonies to misdemeanors. I hope that this answers any questions that you have and just at least gives you an overview of what to expect at a preliminary hearing. Of course, you want to talk to your defense attorney about what to expect at your preliminary hearing, like which witnesses will show up. But I hope that this was helpful, and if you do have any questions and you have a criminal case in California, feel free to give me a call. My number is down below. You can also book a consultation with me there.